For the big story of the day, our discussion on left, right and centre. In a special weekend hearing, the Supreme Court today suspended a Bombay High Court decision to discharge GN Saibaba, a 55-year-old wheelchair-bound academic, in a case under the Unlawful Activities Act, or the UAPA, for alleged Maoist links. Professor Saibaba has been in custody for over 7 years since his arrest in May 2014. A trial court had found him guilty and sentenced him to life imprisonment in 2017. After a nearly 2-hour-long hearing in a special sitting held on a Saturday, a 2-judge bench, which sat on a non-working day to hear the matter, also rejected Professor Saibaba's request, or his lawyer's request, to put him under house arrest in view of his physical disability and health conditions. Professor Saibaba is wheelchair bound due to post-polio paralysis. The Supreme Court bench said that the offences involved are very serious in nature and that the accused were convicted after detailed appreciation of the evidence. On Friday, more than 7 years after his arrest, the Bombay High Court acquitted Professor Saibaba in this Maoist links case. It held, that is, the Bombay High Court held, that the trial was null and void as valid sanctions that were required under Section 45 of the UAPA were not obtained. The Supreme Court, however, observed that procedural safeguards, this is a quote here, procedural safeguards cannot be sacrificed at the altar to a perceived peril to national security. Now, in court, Professor Saibaba's counsel also drew the court's attention to his physical disabilities, saying that he's 90% paralyzed. He is a paraplegic. He is confined to his wheelchair. The lawyer told the court that there are no trained persons in prison to help Saibaba answer the calls of nature. He said that lay co-prisoners are helping him. It is a case of life and health for him, his lawyer argued in court. Remember also, one of the accused in this case, Pandu Pore Narote, died after contracting swine flu in jail on August 2022. All the other accused in this case were acquitted in that Friday Bombay High Court hearing. So, we're asking tonight on left, right and centre. The top court says that bail is the rule, jail is the exception. But Saibaba's acquittal is stayed within 24 hours. His request for house arrest is rejected. No leniency for a man with 90% disability. Compare this to the case of Pragya Thakur. She gets relief on medical grounds. Relief on medical grounds for a MP, but not for activists. Joining us on the show, Mahmood Paracha, senior advocate of the Supreme Court. Ashwani Dubey, advocate in the Supreme Court. We have advocate Mahima Singh, spokesperson also of the Congress. And PKD Nambiar, a BJP supporter. So, Mr. Nambiar, to you first, but let's just pull up these shots because we have the BJP MP, Pragya Thakur. We've seen these visuals. She's playing volleyball, she's dancing, I think she's playing basketball. She is a terror accused. The same UAPA charges, also a UAPA case, but you have her dancing there. All of this while she's out on bail on medical grounds. This is a mockery, really. If you look at those visuals, let's blow up the visuals. Let's let everyone see them. It's a mockery of the court. She's so unabashed, makes no effort to even hide it, possibly secure that she has political connections or political protection. She can, bounce in and out of a wheelchair. She's been given bail. She's been exempted from court appearances because she says she has health issues. Compare this with what's going on in today's case, Mr. Nambiar.
Well, I think it's a matter which is, I can understand there is a large number of people who are in supportive of or who are celebrating his the Bombay High Court's order for him to be acquitting him. But then I think I believe in our judiciary, and I believe that you and even the viewers knows that the Supreme Court of India is considered to be one of the most impartial judicial system in the world. And I trust my judicial
the public is wondering, they're scratching their heads because you have two persons convicted under UAPA charges. Both are terror cases. This is the Malegaon blast attacks. One is an MP, one is an activist. Are there different rules for MPs? Are there different rules for people who have political connections? I ask you this because in the same day we had the Dera Sacha Sauda chief who's been released on parole. Yes, parole is not medical grounds. But clearly we have the elections coming up and he has political protection perhaps.
Well, that may not be true. I think we are just reading too much on this particular case. I think, on the other hand, I wanted to ask you another question. Is the intellectual in this country who may be working against the system, using our own resources, whether intellectual or even pushing the people from our Naxalbari, thousands of people have been killed through the Naxalbari system. The amount of wealth have been, so many of our CRPF, CISF or the army and the police professional personals have been killed.
Mr. Nambiar, whether or not you agree with the ideology of Professor Saibaba, I'm not here to agree with the ideology of Professor Saibaba, neither are you.
May I ask you
I am just asking, are you depriving somebody liberty selectively? And if that is true, is that not a travesty of the law?
I think you started by saying that the norm is either the bail is the norm and jail is only an exemplary cases. But in the case of if the Supreme Court has taken a strong stand, I would like to believe that there may be a serious charges against him. There may be enough proof for the Supreme Court of India to take a decision on him. He is an individual. He is not a mass movement. He is not somebody who is a very political relevant person. So even if you wanted to think of some kind of a conspiracy against this particular, I don't know what you are trying to say. Is the Supreme Court of India has taken a bad decision? Is it we should not be believing in the decision of the Apex Court of India? And secondly, one more point you mentioned that the people in this country is thinking other way around. I don't know which people you are mentioning. If you open up the social media, the number of people and the kind of tweets or the social media messages
argument, should the court go by what the public feels on social media, whether you have read it or whether I have read it, or should the court go by the law? Let's bring in Ashwani Dubey. He's an advocate. That is my point. Irrelevant to what the public thinks. Irrelevant to what panelists on left, right and centre think. The court has to go by the rule of the law.
So they have
Ashwani Dubey, advocate in the Supreme Court, please come in over here. The Supreme Court said today that it is the mind, not one's physical ability, that is important in terror crimes. Because we had the lawyers for Professor Saibaba saying that he's very unwell. He's a paraplegic. He is 90% paralyzed. He's wheelchair bound. He can't go anywhere. Just keep him at home. There's nobody to treat him. In response to that, the Supreme Court said, hold on, let me just finish. The Supreme Court said the mind is what matters, not physical ability. The mind is important in a terror crime. Similarly, BJP MP Pragya Thakur, she's also an accused in a terror case, in the Malegaon blast case. Would the same not hold for her, that the mind is more important while she's out on bail on medical grounds?
Thank you, Sarah, for having me here. Sarah, first, it is an admitted fact that the bail is a rule. Jail is exemption under the exception under the criminal law, criminal jurisprudence. But at the same time, UAPA is a specialist statute which has been enacted by the parliament to deal with the cases related to the terror. Let's do not discuss what has happened in Mr. Saibaba's case. Now, the second is what Supreme Court has not found him as of now, not declared him guilty. Trial court found him guilty. High Court on technical ground, as you rightly said, under section 45, in the absence of the sanction, acquitted him. Supreme Court says no. Formulated four questions. One, that whether after the conclusion of trial and the accused is convicted on merits and on appreciation of evidences, where the High Court was justified in discharging the accused. Two cases can't be acquitted together because the facts of the case of both the cases are different. Be it the Pragya Thakur's case or be it Mr. Saibaba's case. Both cases have a different footing, different facts of the case as well as the different evidences. Now what is to be seen here? The court has not set aside the judgment of the High Court.
Yes, it's
matter is still pending on December 8th.
Yes.
Now medical condition is one of the essential conditions. The court has to look into that even in the jail, a person should not be denied by the medical facilities and his life, liberty should be protected. This is an admitted fact. But the question here is that all of them were convicted for their alleged Maoist link. I am again using the word alleged. And for waging war against the country. Ultimately, unless the top court reaches to the conclusion that whether the judgment of the High Court was based on the merits as well or only a technical question was taken, that is the issue, and I think that the December 8th is coming.
Okay, so you're pointing out, and let's remind our viewers that the court has only suspended for now the decision of the High Court. Fine, fair enough. Mahmood Paracha, let's take this further then. You're a senior advocate at the Supreme Court. Is it then odd let's say, that you have an acquittal order, the matters listed in front of Justice Chandrachud, the Chief Justice had risen for the day. One justice refuses to stay the acquittal, says the SG will should move the Supreme Court on Monday. But then on Saturday, you have a new bench that sits. It's a non-working day that suspends the acquittal order. The only question is being asked about this, the urgency to act on this case. Is that unusual? A 2-hour sitting on a weekend.
That is quite unusual, especially if the government of India and especially the worthy Solicitor General of India, Mr. Tushar Mehta, was not able to show such an urgency that heavens are going to fall. That if this man is released, not released on bail, but this man, after getting acquitted from a very long trial, is getting acquitted, then if he is released, it will be a national emergency, unless you could have shown that. That was not even the argument which was placed before the Honorable Court. So this is quite unusual, and we are seeing our Solicitor General actually overpowering the Attorney General also. Every day we are seeing this. So this is something which is to be really, one should be concerned about in the Supreme Court. That is one. Two, but the main point I want to highlight here is, see, in these stringent laws, the biggest process, it is very well that the process, everybody accepts the process is the punishment. Yes. Now, Mr. Saibaba had got that punishment of the process being so long drawn. Yet, after he gets acquitted, so there is a presumption, and the bail is denied in UAPA cases solely because of a section that is 43D5. That presumption is there in law that a person is supposed to be guilty. I'm just saying that in layman's word, till the time he proves himself innocent. Now, in this case, he has proven himself to be innocent in a court of law. So that presumption of guilt is not there. So therefore, he now deserves bail, more so because he's gone through such a long protected trial.
You're saying the High Court, given yes. what the High Court's ruling was. Now yes. You have to start off from scratch based on what the High Court ruling was.
Okay. This is something very unusual, and this is something which I can very safely say that this is against the principles of natural justice as well as the law laid down by the Parliament and in the Supreme Court itself, especially in case of Pragya Thakur and Lieutenant Colonel Purohit. Just compare the two situations where those persons were granted bail despite the fact that they were not acquitted. So this is the comparison which is a must for the country, people of this country to think and ponder. This is very important.
Okay, so I want to pick up on what Mr. Paracha started off by saying. Has the process become the punishment? We've seen several student activists, they're languishing in jail. Omar Khalid, student leader, in jail for 2 years without bail. Siddiq Kapan, journalist, in jail for over 2 years. Bail in one case, but then awaiting bail in another case being slapped against them. So coming over here again, Ashwani Dubey, because you mentioned, how UAPA is a special exception. So let's just focus on UAPA, because the 2 points you made over there. About UAPA, yes, this leads into then, is the UAPA being used to target anyone that has opposing views, to accuse anyone of being a Maoist sympathizer? Is it being misused by the authorities? Because we know the conviction rates are less than 2% of anyone arrested under the UAPA.
See, the conviction rate, what is the conviction rate in a case does not dilute a case which is primarily registered by the police on the basis of the evidences. Point one. Point two, Delhi High Court, our own Delhi High Court, in the case of Asif Iqbal Tanha, Natasha Narwal, Devangana Kalita, what has held? Right to protest is not a terrorist act under the UAPA. Honorable Supreme Court, instead of sending them back to the jail, is stayed the order saying that it is a wider ramification. So the courts are working independently, impartially, in a transparent manner. This is not the judgment passed by the government, Sarah. Let me make you very clear. This is the judgment passed by an honorable Supreme Court judge.
So your response to the fact that the process is the punishment?
So far as the process of punishment is concerned, you are talking, had it been the case registered under the normal provisions of the Indian Penal Code. And in that situation, if you would have been released, then there is a judgment of Supreme Court as well, 5 judges bench, which says that the bail once granted shall not be cancelled. But here's the question, Sarah, is a legal argument. The case is the trial court has convicted Mr. Saibaba on merits on appreciation of the evidences on record. And thereafter having found the accused guilty for the offences for which they were tried. And the High Court was whether justified in merely discharging on a technical ground. This is the question for which the hearing is fixed. And as rightly said by my dear friend, my dear brother, Mr. Pracha, so far as the section 45 is concerned, that talks about the sanction. But ultimately, the court will decide. Tomorrow, the matter is listed on December 8th. And December 8th, it will be decided whether the provisions
Mr. Parata says even
section...
until it's decided on December 8th, he deserves bail, given the fact that he's been acquitted by the High Court. But I want to, again, you keep raising mention about UAPA. You're saying if this was a normal case under the normal, penal code, then things would have been perhaps different. So let's bring in our advocate, Mahima Singh. Ms. Singh, of course, we can go back to August 3rd, 2019, and I'm not talking even about the UAPA introduced under the previous government, but on the amendments to the UAPA, where the Congress backed the UAPA bill in the Rajya Sabha, breaking with the opposition.
I am glad that you brought that with Vika. And I would like to draw the attention of our audiences to the chronology that we see here. 2017, Pegasus landed in this country. And before I begin on my merit points, I would like to sympathize with the BJP supporter here, because in all these critical debates, we see the BJP spokespersons missing. That's unfortunate. So 2017, the alleged entry of Pegasus happens in this country. And thereafter, we see, event after event, which is very unusual to have happened in the last 75 years of the history of this independent democratic nation. I heard many panelists talk about whatever went on in the Supreme Court. My question to you is the fact
that the amendments to the UAPA bill were supported by the Congress, who broke with the opposition to do it. The Congress broke ranks with many opposition parties in the Rajya Sabha. They supported this unlawful activities prevention amendment bill in 2019.
Indeed, because you see, it was done with earnest intention to protect the integrity and sovereignty of our country, not with the intention to falsely frame the intellectuals, the writers, the journalists.
But there were many opposition. There were many who were pointing out that this is likely to be misused. And this is India. We've had TADA before that. We've had so many laws like this that have been misused. Why would you think that this would not be misused?
Because the governments in this country are likely and due to change during the due course of time. But since you have named Pragya Thakur...
But wasn't the case against Professor Saibaba filed under the UPA government?
All right. In fact, if it was, in 2017, as I said in 2017, this software happened. And then there's Sudha Bharadwaj, and then there is Tel Tumbre, and then there are the killings of Gauri Lankesh, Kalburgi. All of this to a layman and to anybody who thinks with the right mind looks like it is interlinked.
Ma'am, I just want to remind our viewers that after a heated debate in the Rajya Sabha on that approved these crucial amendments to the Unlawful Activities Prevention Act, which basically allowed the centre and the state to then designate even an individual as a terrorist and seize their property. Surely as a politician, surely as a representative of the people in Parliament, the Congress should have known that this will be misused by the opposition. But I want to bring in PKD Nambiar. At that point of time, in 2019, you have the Home Minister Amit Shah giving his assurance that there will not be a misuse of this.
Absolutely. Well, first and foremost, the Congress spokesperson, I think she was not prepared enough when she came for this debate. The one is that Mr. Saibaba was not booked under the BJP rule, both at the center and the state. Yeah, both at the center and the state, it was the Congress ruled. UAPA was not brought by the BJP in India, neither the TADA. It was all brought by the in the interest of the country by the Congress then government. I consider that it is in the interest of the
Tightened
country.
by this government, tightened by the Modi government.
Absolutely.
Home
Now,
Minister
every
stood
law-
on the floor of Parliament, gave his assurance that there will not be a misuse.
Now,
They went from terming an entire organization as a terrorist organization to terming an individual as a terrorist. You can take away his private property based on these charges.
Of course it is. Indeed, it is the national security is the utmost important, whether it is an individual who is working against the nation, whether it is a group of people or an organization, these laws are made to protect the country, you and me. I think let us support that. Now coming to the one large question. I don't have the data right now with me. Maybe Ashwani ji would have it.
Are you also not prepared?
That I am giving you one data. Only one thing I wanted to say. In this country, that how many state governments, including our home state Kerala to the Kashmir, how many state governments have booked people under UAPA, and how many of them are from BJP government, how many of them are Congress-led government or the opposition government. And I am of the opinion all the regional, all the states or the other places, irrespective of which political party is ruling, if the government feels or if the state feels, our security forces feel, either an individual or a group of people are working against the country in the security of you and me or the people of this country, there these law needs to be applied. And I am of the opinion the Supreme Court of India, the apex court of India, and I believe that this court always go on merit and wherein everybody get the justice, including Mr. Saibaba. He may have to go through, of course.
So you see nothing unusual in the fact that we have a hearing called overnight within 24 hours on a Saturday, on a weekend. Not everybody gets those, those benefits.
Only one thing I wanted to say you. A couple of years back, I did a legal adalat for helping the poor people in Delhi. I realized one thing: the number of people who are not even able to get a bail, who don't even get any kind of media attention. There are thousands of people are across in our jails are struggling to even come out of. They don't even have 1,000 rupees or 5,000 rupees to get their own bail, or somebody
we are
give them a
completely out of
guarantee
time,
to
but
get
I
them
want
bail.
to end
So irrespective
tonight's
of
Left,
any
Right and
individual-
Centre by again remembering Stan Swamy, Father Stanley Swamy, who was one of those accused in the Bhima Koregaon case, an 84-year-old. He suffered from Parkinson's. He got COVID while he was in prison. He was arrested under the Unlawful Activities Prevention Act in October 2020. He was under trial in the Taloja jail in Mumbai, where he died on the 5th of July. Thank you all for joining us on Left, Right and Centre.